Welcome back. It was a crime which pushed everything else off the front pages. 3 men, all known criminals, found shot dead in the Essex countryside. It was a cold-blooded, professional killing. The victims had many enemies, but which one wanted them executed?
And welcome to a brand new series on the Essex Boys case. In this upcoming series, we're going to be taking a look at some information which has recently been released into the public domain concerning potential new eyewitness accounts, Michael Steele's own thoughts on the crime scene and the investigation into the murders themselves, and also the in-depth testing surrounding the mobile phone usage of both the victims and the accused. Firstly, let's take a look at the background surrounding the case in question. Background. Point 1. Mr. Womes faced trial with 2 co-defendants Michael Steele and Peter Corey on an indictment with 5 counts. Count 1, to which all 3 men were defendants, alleged that they had conspired to import cannabis. Counts 2, 3 and 4 related to the murders of 3 men. Patrick Tate, Anthony Tucker and Craig Rolfe. Mr. Womes and Mr. Steele were charged with the murders, but Mr. Corey was not. Count 5 related to the possession as a prohibited person of a shotgun. Mr. Steele was the only defendant to this charge. The prosecution case. Point 2. The Crown's case, in relation to all the counts, relied very heavily on the evidence of Darren Nichols. He was an accomplice to the importation of drugs and was involved in the events surrounding the murders. By consent, the jury was directed to take account of his criminal character and his admitted involvement in the importation of controlled drugs. The jury were directed that in giving evidence for the Crown, Mr. Nichols may well have had an interest of his own to serve in seeking to obtain some lesser sentence than would otherwise be the case. He had lied in his 3rd interview with the police. Mr. Nichols had previously pleaded guilty to and was awaiting sentence upon 4 counts on an indictment relating to the importation of drugs, the sale of a firearm and the possession of drugs. Point 3. Mr. Nichols said that in 1992 he had been in prison for counterfeiting offences. Whilst in prison, he befriended the defendants Mr. Steele and Mr. Womes. In 1993, Patrick Tate moved to the same prison. Mr. Nichols and Mr. Steele already knew him. Mr. Nichols said that he subsequently contacted Mr. Steele and Mr. Tate when they had all been released from prison. In 1994, after they had been released, Mr. Nichols had come to dislike Mr. Tate and they had no longer been on speaking terms. Mr. Nichols carried out some electrical work at a house in Clacton that belonged to Mr. Steele's mother. Around this time, Mr. Nichols said he began to sell cannabis resin for Mr. Steele. He also did some work for Mr. Steele in Brightlingsea, where he, Steele, had a rigid inflatable boat. Mr. Nichols thought that Mr. Steele also disliked Mr. Tate. Drug smuggling. Point 4. Mr. Nichols gave evidence in relation to several trips abroad that he made with Mr. Steele, Mr. Womes, Mr. Corey and others. The first trip was on the 15th of August 1995. He collected Mr. Steele and Mr. Corey and they went together in a car via the ferry at Felixstowe to Amsterdam. There they met a man named Stone, who agreed to sell them a quantity of drugs. They left the money with Mr. Stone and returned to the UK. Point 5. Mr. Nichols and Mr. Corey returned to Amsterdam a few days later to collect the drugs. They went by car via the ferry to Ostend in Belgium. When they left Amsterdam, they telephoned Mr. Steele in the UK. They arranged to meet Mr. Steele on the coast near Blankenberg. Mr. Steele travelled from the UK in his rib. When Mr. Steele arrived, Mr. Nichols and Mr. Corey carried the drugs down the beach and loaded them onto the boat. Mr. Steele and Mr. Corey returned to the UK in the boat. Mr. Nichols telephoned Mr. Womes to tell him that the boat was on its way back before returning to the UK by car via Calais. He was subsequently paid in drugs by Mr. Steele for his part in the importation. Point 6. Mr Nichols said that on the 3rd of October 1995, he and another man, Francis Reed, went to Amsterdam, crossing the channel by ferry from Felixstowe to Zeebrugge. Mr Nichols said that Mr Reed did not know at the outset that the purpose of the trip was to purchase and smuggle cannabis. Mr Nichols bought cannabis from Mr Stone. He then met Mr Steele on the coast near Blankenberg. The boat was again loaded with the drugs. Mr Nichols said that he was then told by Mr Steele that he would be returning with him, Steele, on the boat. Mr Reed returned to the UK by ferry. Mr Nichols said that the crossing in the boat was difficult. The sea was rough and the fuel tank on the boat split. They landed at Point Clear in Essex, where they were then met by Mr Womes. Mr Nichols was again paid in drugs for his part in this importation. Point 7. On the 7th of November 1995, Mr Nichols again went to Holland with Mr Corey. This importation involved the purchase of drugs to the value of £125,000. The money came from various sources, including Patrick Tate. Mr Nichols said that he had collected Mr Corey from Mr Steele's house, where the cash for the purchase was being counted. They travelled from Harwich to Amsterdam as foot passengers and later hired a car in Amsterdam. They handed the money to Mr Stone and then met him to collect the drugs. They drove to the same beach near Blankenberg. Mr Steele picked up the drugs in the boat. Mr Corey returned to the UK with Mr Steele in the boat. The following day, Mr Nichols returned to the UK through Harwich. Mr Nichols said that he subsequently learned from Mr Steele that he, Steele, Mr Womes and Mr Corey had been arrested by the police and customs officers when Mr Steele had landed at Point Clear. The boat had been searched, but nothing was found because the drugs had already been offloaded. The three men had been questioned and released. Point 8. Mr Steele took Mr Nichols to where the drugs had been stored and gave him several kilograms to sell. Mr Nichols passed the drugs on to dealers, but they returned them to him, saying that the cannabis was of very poor quality and was unsaleable. Mr Steele said that he had heard the same thing from other people to whom he had supplied the drugs. Mr Steele contacted Mr Stone, who apologised and said that they had been given the wrong batch, although a third of the drugs were of good quality. He agreed to refund the money if the drugs were returned. Point 9. On the 15th of November 1995, Mr Nichols went with Mr Steele to Amsterdam to collect the money. Mr Stone initially gave them £30,000 and they agreed to wait whilst he obtained the rest of the refund. They stayed overnight in the Delta Hotel. On the 17th of November, Mr Stone provided them with a further 80,000 of guilders, which Mr Steele accepted. Mr Steele was concerned about carrying large amounts of currency back into the UK and made telephone calls to persuade Mr Tate, Mr Womes and others to travel to Ostend to help take the money back. Mr Steele met Mr Tate and two women and gave them some of the money. Mr Womes came over in a van and took the guilders back to the UK. Mr Steele and Mr Nichols returned to the UK by jet foil. Mr Steele told Mr Nichols to dispose of the cannabis and he did so by throwing it in the sandpits at Braintree. Point 10. The Crown adduced evidence to corroborate the account given by Mr Nichols regarding the trips to Holland. There was evidence to show that a call had been made from a bar near the beach in Blankenberg to Mr Womes' mobile telephone, as Mr Nichols had claimed. The ferry tickets in relation to the trip with Mr Reed were paid for on Mr Nichols' credit card and booked in Mr Reed's name. There was an entry in an Amsterdam hotel register showing that Mr Nichols had stayed there on the night of the 7th of November and again from the 15th to the 17th of November. There was a booking in Mr Steele's name for a hotel in Ostend. The sandpits at Braintree were searched and blocks of cannabis resin were found. Point 11. Barry Dorman, a business associate of Mr Tate's, gave evidence that he had gone to Ostend with him to collect money. Craig Rolfe and Tony Tucker had also gone with them, as had some of their girlfriends. Point 12. Evidence was given as to the arrests of Mr Steele, Mr Womes and Mr Corey on the night of the 7th/8th of November. In the early hours of the morning, police officers saw a Range Rover with a trailer and a rib attached. Mr. Womes spoke to the officers and said they had been diving. Mr. Corey and Mr. Steele appeared and began to do some work on the boat. Officers of HM Customs and Excise arrived and arrested Mr. Steele, Mr. Womes and Mr. Corey on suspicion of importing drugs. The boat was searched but nothing of significance was found. It was taken away for examination and a very small piece of cannabis resin weighing about 1/4 of a gram was found. Point 13. The three men were interviewed. Mr. Steele and Mr. Womes refused to answer any questions. Mr. Corey said he had been out with Mr. Steele to help him test the boat and its onboard computer. The boat, he said, had broken down on a number of occasions. The three men were released without charge. The murders. Point 14. Mr. Nichols said that on a number of occasions prior to the murders, Mr. Steele had asked him if he could get hold of a gun. On the 6th of December 1995, he had spoken to Mr. Steele on the telephone a number of times. He met him by arrangement at around 5 p.m. Mr. Womes was also present. Mr. Steele said he was going to collect some others and bring them to a place where a drug deal was to take place. Mr. Womes and Mr. Nichols went in a Volkswagen Passat to the car park of the Halfway House pub where Mr. Steele was already parked in his Toyota Hilux. They watched and saw a Range Rover arrive and park next to Mr. Steele's vehicle. Mr. Womes said that Mr. Tate was in the Range Rover. Mr. Womes then told Mr. Nichols to drive to Rettendon and turn off the road on a farm track to the right. Mr. Womes got out of the car there, taking a canvas bag with him. Mr. Womes told Mr. Nichols to wait for his telephone call and then come back and get him. Point 15. Mr. Nichols drove off to another pub to wait but could not obtain a good signal on his mobile telephone there, so he drove back past where he had dropped off Mr. Womes and parked in Rettendon. Mr. Womes telephoned and said, "Come and get us." Mr. Nichols returned to the farm track and Mr. Womes and then Mr. Steele got into the car. Mr. Womes was wearing plastic gloves which appeared to be speckled with blood. Mr. Steele told Mr. Nichols to drive off, which he did. Mr. Steele said, quote, "They won't fuck with us again," and Mr. Nichols assumed from this that someone had been killed. He saw Mr. Steele pass over parts of a shotgun to Mr. Womes. Mr. Steele described Mr. Womes as cold-hearted because Mr. Womes had handed Mr. Steele a gun and then Mr. Womes had immediately shot all three men in the Range Rover. Point 16. Mr. Nichols said that he learnt of the identity of the other two victims from the news. Mr. Steele told him sometime after the murders that the three men had been tempted to the scene by a story of a cocaine deal. The cocaine was to be imported by plane. Mr. Steele told him that the gun had been ground up and thrown into the sea. Mr. Steele said that Mr. Tate had borrowed some money from two brothers to buy the drugs and failed to repay it. He had told the brothers that Mr. Steele had not repaid him. Mr. Steele had heard that Mr. Tate had planned to deliver him to the brothers and to shoot him in front of them. Point 17. A few days after the murders, Mr. Nichols had been offered a shotgun and had agreed to buy it. He passed it on to Mr. Steele. A shotgun was later found by police hidden in a loft at Mr. Steele's house. Point 18. The bodies of the three victims were discovered in the Range Rover by two local farmers at around 7:45 on the morning of the 7th of December 1995. A forensic scientist gave evidence that he believed that 8 shots had been fired. 7 cartridge cases were recovered, all of which had come from the same weapon. Point 19. The Crown adduced evidence of telephone calls made between the telephones belonging to the parties from August 1995 until after the murders. Evidence was given regarding the location of mobile telephone transmitters and the routing of calls on the day of the murders. 2 calls were made from Mr. Womes' mobile telephone to Mr. Nichols' mobile telephone at 18:59. One call lasted only 1 second, indicating a poor signal. It was the Crown's case that the calls were made from the vicinity of Workhouse Lane, the site of the murders. The Crown brought forward evidence to show that the second call at 18:59, which lasted 4 seconds, was routed through a transmitter sited at Hockley, and that this was consistent with the call having been made in the Workhouse Lane area. Point 20. The court heard evidence in relation to the mobile telephones of the two victims, Patrick Tate and Anthony Tucker. The billing data for those telephones showed that the last calls they made were at 17:07, Tucker's mobile lasting 2 minutes and 9 seconds, and 18:26, Tate's mobile lasting 26 seconds. The billing data for Mr. Tucker's mobile showed that a number of incoming calls were diverted to his voicemail from 1909 onwards on the 6th of December 1995. There was no evidence that he attempted to retrieve the voicemails which were left. The available cell site data for Mr. Tate's mobile suggested that the last incoming call which he answered began at 18:44 on the 6th of December 1995. The Crown relied on the timing of the various calls to suggest that the victims were murdered at some point between the end of the 18:44 call to Mr. Tate and the beginning of Mr. Womb's 18:59 call to Mr. Nichols. Claire Carey arrived at Mr. Tate's address to meet him. The lights were on and music was playing. Mr. Tate had left a note saying that he had to pop out for half an hour and asked her to wait. He did not return. The court also heard evidence that the victims had a dinner reservation at the Global Net Cafe in Romford at 20:30 on the evening of the 6th of December. It appears that they intended to attend. The reservation had been rearranged that day. None of the victims attended the restaurant, nor was there any evidence that they had contacted anyone to explain their absence. Point 22. Mr. Steele and Mr. Wombs were arrested and interviewed under caution in relation to the murders. They made no substantive replies when questioned. The defence case. Mr. Steele. Point 23. It was Mr. Steele's case that he had been testing his boat rather than importing drugs when he was arrested on the evening of the 7th-8th of November 1995. He had been elsewhere at the time of the murders. Point 24. It was put to Mr. Nichols in cross-examination that it was Nichols who had been importing drugs and that Mr. Steele had only gone with him to Holland to assist him in recovering money. It was put to Mr. Nichols that he had, with the assistance of a corrupt police officer, set up Mr. Steele and Mr. Wombs in relation to the murders. Mr. Nichols denied these allegations. Point 25. Mr. Steele gave evidence. He had previously been convicted of importing drugs by plane and served a 9-year sentence. He had bought and adapted the boat but used it for diving. He had not asked Mr. Nichols to obtain a gun for him and knew nothing about the gun found in the loft of his house. The telephone conversations between Mr. Nichols, Mr. Wombs and himself on the 6th of December had been in relation to collecting a trailer from one of Mr. Wombs' relatives to pick up Mr. Nichols' car that had broken down. Mr. Steele had collected the trailer and then gone home where he saw some people who were interested in buying his house. He had not revealed this to the police when interviewed because he was advised not to answer questions. The defence case for Mr. Wombs. Point 26. Mr. Wombs gave evidence and denied any involvement in drugs importation or the murders. He had gone out in Mr. Steele's boat on the 7th of November to help test it. He had gone to Ostend with Mr. Steele to help him bring back some money for Mr. Nichols. On the 6th of December, he had gone to collect a car for Mr. Nichols. Mr. Steele had helped him by collecting a trailer to put the car on. He had not answered questions in interviews because he realised that Mr. Nichols was trying to implicate him in the murders and was concerned that if he said the wrong thing, he might implicate himself in something that he had not done. Verdicts. Point 27. Mr. Wombs, Mr. Steele and Mr. Corey were convicted of conspiracy to import drugs. Mr. Wombs and Mr. Steele were convicted of the murders of Messrs. Tate, Tucker and Rolfe. Mr. Steele was acquitted of possession of the shotgun. Previous appeal history. Point 28. On the 12th of February 1998, Mr. Wombs applied for leave to appeal against his convictions. His grounds, which were drafted by counsel, were as follows. Number 1. Severance. The judge was in error and exercised his discretion wrongly in rejecting 2 defence applications to sever the drugs counts from the murder counts. The first application was made prior to trial, and the second, to sever the counts and to grant retrials, was made at the close of the Crown's case. Point number 2. No case to answer. The judge was in error in refusing to remove counts 2, 3 and 4 from the jury, in that, taking the evidence of the Crown at its highest, no reasonable jury properly directed could safely have convicted on it. Point 3. The evidence of Jasper. The judge was in error in refusing to allow Mr. Womes, through counsel, to ask certain questions of a witness, Mr. Jasper, called by Mr. Steele. Point 4. Mobile telephone evidence. The judge erred in his summary of the mobile telephone evidence and failed properly to assist the jury to assess the significance of this evidence. And point 5. Irrational verdicts. The verdicts of the jury were inconsistent in that the Crown's case on each count relied on the evidence of Darren Nichols. The jury must, in deciding to acquit Mr. Steele of the offence of possession of a firearm, have rejected Mr. Nichols' account. The other convictions that were based on his evidence were inherently unsafe. Section 29. Mr. Womes submitted additional grounds of appeal on his own composition. Section 30. On the 6th of July 1998, the single judge refused leave to appeal against the convictions. Section 31. On the 25th of January 1999, the full Court of Appeal considered and refused a renewed application for leave to appeal. In refusing leave to appeal, the Court made the following observations. Severance. The learned trial judge exercised his discretion correctly regarding severance of the counts on the indictment. It would have been artificial to invite the jury to hear the murder counts on their own, since it would have appeared to have been an entirely motiveless crime which they would have found difficult to understand. No case to answer. The court agreed entirely with the trial judge's decision that there was a case for the defendants to answer. Evidence of Jasper. The judge was correct to exclude the evidence that Mr. Womes sought from the witness Jasper, as it was clearly hearsay. Mobile telephone evidence. There was no reason to criticise the way in which the trial judge dealt in his summing up with the evidence of mobile telephone calls. The judge delivered an extremely long, but also extremely fair, comprehensive and neutral account of the evidence. In view of the length of the trial and the degree of care which was devoted to the issues, the court thought it unlikely that the jury were not fully alive to what the issues were. Irrational verdicts. It was not irrational for the jury to acquit on count 5 and to convict on the first 4 counts. The evidence on count 5 was quite different. Section 32. Mr. Womes applied to the Commission on the 15th of May 2002. Following a lengthy review which included a Section 19 investigation, the Commission referred the case to the Court of Appeal on the 15th of December 2004. The case was referred because there was new evidence that, before the trial, Mr. Nichols entered into arrangements with sections of the media whereby he was to be paid or expected to be paid for his story, and those matters were not disclosed by the Crown. In view of the use that the defence could have made of the new evidence in attacking Mr. Nichols' credibility and the centrality of his evidence to the Crown's case, the Commission considered that there was a real possibility that the Court of Appeal would quash the convictions. The Commission also considered there was a real possibility that the Court of Appeal would receive new evidence from a mobile phone expert, David Bristow. Section 33. On the 22nd of February 2006, the Court of Appeal considered the safety of Mr. Womes' convictions alongside those of Mr. Steele and Mr. Corey. The following grounds were argued before the court on that occasion. Point 1. Fresh evidence regarding Darren Nichols' contact with the media undermined the credibility of his evidence and the police investigation. Point 2. Fresh expert evidence from David Bristow regarding the cell site analysis of mobile phone calls made around the time of the murders cast doubt on the safety of the convictions. Point 3. The trial judge misdirected the jury on their right to draw adverse inferences from Mr. Steele's failure to answer questions when interviewed by the police. Section 34. The Court of Appeal upheld the convictions and dismissed the grounds of appeal for the following reasons. Regarding Darren Nichols' contact with the media, Section 35. Quote, First, all the essentials of Nichols' account had been imparted to police officers in interview and reduced to witness statements before he had any dealings with Thompson or any other members of the media. Although the defence case at trial was that what occurred in the interviews was the tip of an iceberg of collaboration between Nichols and Detective Constables Brown and Winston, there is not a shred of evidence to support such a contention. The issue was resolved by the jury and there is no new evidence to the contrary. Secondly, Nichols' account was long and detailed, and in all important respects it remained consistent throughout. He was in the witness box for almost 3 weeks and was rigorously cross-examined by counsel for all 3 appellants. Thirdly, this was not a case in which the defence had no material with which to cross-examine. The material at the disposal of the defence enabled them to present Nichols to the jury as a time-served criminal of some sophistication, a dishonest drug trafficker, and a man with a corrupt relationship with a police officer. He was plainly a manipulative man with his own interests to serve. He told the jury of the long time he had spent in the company of police officers leading up to the trial, in the course of which they had been anxious that he might fail to come up to proof. Notwithstanding the volume of material which the defence were able to throw at Nichols, the jury remained sure, and unanimously so, about the essentials of his account of the drug importations and the murders. In those circumstances, if the jury had known about the media contacts and Nichols had admitted them as he would have been bound to do, although those contacts are to be deprecated, it is difficult to see how they could have added significantly to the cross-examination armoury in the circumstances of this case. Fourthly, although the jury were convinced by Nichols' account of the essentials of the drug importations and the murders, it is implicit in their verdict of not guilty on count 5, the firearms charge, that they did not accept his evidence about everything. Baroness Kennedy seeks to turn that to the advantage of the appellants by submitting that, in effect, having started down the road to disbelief, the jury might have travelled further with one more push. However, the combination of factors is equally susceptible to the analysis that the jury were prepared to accept Nichols on the drug importations and murders, notwithstanding his many personal shortcomings and in spite of the fact that they were unpersuaded by his account of one of the offences alleged on the indictment. For our part, we consider it virtually certain that the jury would also have rejected that part of Nichols' evidence where he sought to minimise the involvement in and knowledge of the drug importations by his friend Francis Reed. We cannot escape the conclusion that the jury, mindful of Nichols' personal shortcomings and accepting that he had probably not told the truth about, for example, the firearm and Francis Reed, were nevertheless utterly convinced by his account of the essentials of the drug importations and the murders. Fifthly, it is important not to forget the other evidence in the case. Nichols' account of the drugs importations was supported by a quantity of documentary evidence which confirmed aspects of his account, although to the extent that it did so, the appellants also proffered explanations which were consistent with that material. Nevertheless, the evidence of the arrest of the appellants in proximity to the boat on the 8th of November and the finding of a small trace of cannabis in the boat gave some support to Nichols' account. So far as the murders were concerned, the telephone evidence, to which we shall return, was, in our judgment, strongly supportive of Nichols' account. Moreover, although still called alibi witnesses, the prosecution succeeded in proving that the alibi was false. Sixthly, even if, contrary to the view we have expressed, a reasonable jury might conclude that Detective Constables Brown and Winston had been less than candid in their evidence to this court about their knowledge of Nichols' contacts with Thompson and the media, that does not undermine Nichols' trial evidence to a material degree. Regarding the cell site analysis of mobile phones, section 36. The court heard Mr. Bristow's evidence before deciding whether to receive it under section 23 of the Criminal Appeal Act 1968. Having heard the evidence, the court declined formally to admit it, being satisfied that it was not new evidence. In reaching this conclusion, the court referred to the following points, which rendered the new tests less reliable than the tests conducted for trial. Point 1. When he conducted his original tests pre-trial, Mr. Bristow had not used Mr. Wome's phone, but one of the same make and model. When conducting the new test, Mr. Bristow used Mr. Wome's actual phone, but Mr. Wome's phone may have degraded in the intervening 5 years since the original tests were performed. Point 2. The conditions of the cell site had changed in the intervening 5 years. Point 3. Mr. Wome's phone was an analogue model, and analogue usage had declined markedly in the intervening 5 years, which would alter the conditions. Section 37. Additionally, the court noted that Mr. Bristow stated when giving evidence for the appeal that he remained of the same opinion that he had given at trial. Adverse inference from silence. Section 38. The court accepted that the direction given at trial was different from the direction recommended in the current Judicial Studies Board directions, but noted that a change in the law would not automatically render a conviction unsafe. The court stated that it was, quote, very likely the judge's directions would be different if the matter were to be tried now. However, in the circumstances of this case, we do not think that any injustice whatsoever resulted from the directions which were given. No doubt as to the safety of the conviction is raised in our minds by this point, and accordingly this ground of appeal is also rejected. The applicant's submissions. Section 39. On the 6th of August 2006, Mr. Womes applied to the Commission for a second review of his conviction. Throughout the course of the Commission's review, more than 60 letters have been received from Mr. Womes containing additional submissions in support of his application. Mr. Womes has also provided the Commission with various supporting documents, including 2 expert reports by David Bristow, dated June 2007 and the 14th of July 2009. The Commission has also met with Mr. Womes on 2 occasions to discuss his application, on the 19th of September 2008 and the 1st of June 2010. In addition, the Commission met with Mr. Womes' representative Christopher Bowen at the Commission's office on the 25th of June 2009. Issue 15. It is submitted that Donna Jagger's witness statement, dated the 14th of the 3rd, 1996, contradicts her account as reported by D.I. Florence in his report dated the 8th of the 12th, 95, and the police message M93, also dated the 8th of the 12th, 95. The Commission has considered Miss Jagger's witness statement dated the 14th of March 1996, report R4 by ex-DI Florence and police message M93. The Commission notes that the CPS disclosed report R4 in slightly redacted form to the applicants before their trial on the 11th of April 1997. It was forwarded to Defence Counsel on the 23rd of April 1997. It follows that report R4 was available to be utilised in the applicant's appeal hearings in 1999 and 2006. In any event, the Commission does not consider Miss Jagger's account as described in report R4 to be inconsistent with her trial evidence. The Commission notes that message M93 refers to Miss Jagger's last seeing Mr. Rolfe on the morning of the 6th of December 1995, rather than at around 5:45 on the evening of the 6th of December, as she stated in her trial evidence. The applicants have not informed the Commission when message M93 was disclosed to them, but the Commission recognises that it could have been used in cross-examination of Miss Jaggers at trial if it had been available to the defence at that stage. The Commission has considered the apparent inconsistency between the times referred to in message M93 and Miss Jaggers' trial evidence. The Commission takes the view, however, in the context of the rest of Miss Jaggers' evidence, that any such inconsistency does not give rise to a real possibility that a Court of Appeal would find Miss Jaggers to have been unreliable in her account. In the context of the rest of the evidence in this case, the Commission does not consider that message M93 is capable of giving rise to a real possibility that a Court of Appeal would overturn the convictions if the case were referred now. Issue 16. Mr. Steele submits that on the 6th of December 1995, since it was, quote, rush hour on a snow-driven night, end quote, Mr. Tate could not have travelled from the Halfway House pub at 18:30, where Nichols claims to have seen him, to Workhouse Lane at 18:44, where he is alleged to have been when he received a call from Sarah Saunders. It is also submitted that Tate could not have travelled from his home address to the Halfway House pub in the 24 minutes between the last call to Claire Carey and Nichols' alleged sighting of Tate at 18:30. Issue 17. Raymond Wright, a witness who gave evidence at trial, described a Range Rover turning into Workhouse Lane at approximately 1900 hours on the 6th of December 1995. The description of this vehicle did not match that of the Range Rover that the three deceased were discovered in on the 7th of December 1995. As the applicants acknowledge, Mr. Wright gave evidence at trial. His evidence was also relied upon at page 30 of Mr. Steele's Grounds of Appeal, 22nd of June 1998. Mr. Wright's account does not constitute new evidence or argument for the Commission's purposes. The argument that the Range Rover, which was witnessed by Mr. Wright, was not that of the victims, was explored in cross-examination at trial. Issue 18. The cannabis, which was alleged to have been found in the rigid inflatable boat. It is submitted that police message M622, which formed part of the unused material at trial, contradicts the Crown's version of events as presented at trial by witnesses Daphne Lidstone and John Willier in relation to how traces of cannabis were found in the rigid inflatable boat. The Commission acknowledges that the version of events contained in this message is factually inconsistent with the Crown's case at trial, in that it was never contended that cannabis was discovered in the rib on the 8th of November, nor was it contended that the drugs were discovered by a sniffer dog. Message M622 could, therefore, have been used in cross-examination of the Crown's witnesses in relation to this issue. However, in the context of the case as a whole, the Commission does not consider that this message, which was available at trial in any event, gives rise to a real possibility that the convictions would be overturned by the Court of Appeal if the case were referred now. Although there is an arguable inconsistency, it does not show that the Crown's trial version of how the cannabis was discovered must be false, or that state agents were responsible for planting the cannabis in the rib. In support of their allegation that officers of HM Customs and Excise planted the cannabis which was found in the rib on the 10th of November, the applicants point out that the amount said to have been discovered was similar in quantity to that seized from the home of Gordon Stevens from his beach property known as Feronia on the 8th of November. The applicants also rely upon the fact that no drugs were found when the rib was subjected to a rigorous search on the 8th. The Commission has considered the submission that the drugs were planted by Customs and Excise, but notes that there remains no evidence that this actually occurred. This submission is an unsubstantiated allegation which, in the absence of any evidence, cannot form the basis of a referral to the Court of Appeal. Issue 19. Request for further disclosure in relation to possible alternative suspects. The applicant submits that police intelligence from 1995 and 1996 suggested that Paul Edwards, Ray Sullivan and Michael Bowman were involved in a, quote, plot to kill Tate, Tucker and Rolfe. The applicants point out that Paul Edwards drove a Range Rover in December 1995. It is suggested that this may be the vehicle which was seen entering Workhouse Lane by Raymond Wright, and that shortly before the murders he had, quote, fallen out with Mr. Tucker. The applicants request disclosure of any new information that the Commission has obtained in that regard. The Commission has considered this submission and request, but can confirm that no new information has been discovered in relation to Edwards, Sullivan or Bowman, or of a plot to kill Tate, Tucker and Rolfe by any alternative suspects which has not previously been disclosed to the applicants. Section 83. Mr. Steele submits that it is a, quote, cause for much speculation, end quote, that no house keys were discovered on Mr. Tate's person at post-mortem. The Commission notes the officer's report of D.C. Winston, dated the 11th of December 1995, which states that he was at Mr. Tate's address with Sarah Saunders on the 9th of December, when Liz Fletcher arrived and returned, quote, front door keys to the premises, keys to the Mercedes car, index Echo 532 November Mike uniform, and Miss Saunders' mobile phone, end quote. The Commission also notes that Sarah Saunders described this event in her police interview. The Commission acknowledges that this still does not explain why Mr. Tate had no house keys on his person, since he was not scheduled to meet Miss Fletcher on the evening in question, but had arranged to meet Claire Carey at his house. She apparently had no door key either, according to her witness statement S21, dated the 8th of December. She waited outside Mr. Tate's address for him to return. In addition, it could be presumed that Mr. Tate had house keys in his possession when he left the house and locked up the premises, leaving a note for Miss Carey. The Commission observes that this anomaly regarding Mr. Tate's house keys has been known about since December 1995. The Commission has not discovered any new evidence which advances the issue any further. In the absence of such new evidence, Mr. Steele's submissions on this point cannot form the basis of a referral to the Court of Appeal. Mr. Steele argues that the absence of house keys must mean they were taken from Mr. Tate after the murders, i.e. evidence was removed from the scene of the crime. It has also been suggested that one or more mobile telephones may have been removed from the crime scene, e.g. mobile telephone 0585 249 316, associated with Mr. Tate and Liz Fletcher, one of his girlfriends, or one of the handsets that had previously been associated with Mr. Rolfe. The Commission considers it to be pure speculation that items have been removed from the crime scene. There is no evidence to support such a contention. In the absence of any new evidence on this point, Mr. Steele's theory cannot give rise to a real possibility that the convictions would be overturned by the Court of Appeal. Issue 5. Submissions in relation to telephone data. Section 86. Point 1. The applicants submit, relying on the expert report of David Bristow, dated June 2007 and revised in October 2007, that the trial jury was misled on the issue of whether or not the victims answered any incoming calls to their mobile telephones after the critical 1859 call between Jack Womes and Darren Nichols on the 6th of December 1995. It is further submitted that the Court of Appeal erred on this subject when it was considered in February 2006. At paragraph 10 of its 2006 judgment, the Court of Appeal stated, quote, "The case for the prosecution was that the murders took place between 1848 and 1859, and that the telephone evidence supported this. It is a fact that the mobile phones of the deceased men did not make or receive effective calls after that time." End quote. David Bristow has argued that it would have been more accurate to state that there was, quote, "no sound evidence put before the court that the deceased men did or did not make or receive any calls after that time." In relation to Mr. Tucker's phone ending 327, Mr. Bristow states that the jury should have been informed that both the itemised billing and the Vodafone toll ticket only registered calls which Mr. Tucker could be charged for, i.e. outgoing calls and incoming calls which were passed to his voicemail. By way of illustration, Mr. Bristow points out that calls from 01268 558 162, which Mr. Tucker answered at 12:21 and 14:02 on the 6th of December 1995, did not appear in the Vodafone toll ticket beacon data for his phone. Mr. Bristow contends that Vodafone would have had no record of incoming calls to Mr. Tucker's phone which were not passed to voicemail. He adds that this leaves open the possibility that Mr. Tucker answered incoming calls after 1900 hours on the 6th of December. The Commission has considered this submission and takes the following view. Even if it is correct that the available records do not rule out the possibility of post-1900 incoming calls which were answered by Mr. Tucker, there remains no positive evidence that he did in fact answer such calls. In the absence of evidence on the point, it is difficult to see how this submission could give rise to a real possibility that the Court of Appeal would overturn these convictions. In addition, the Commission observes that there was other evidence which suggested that it was highly unlikely that Mr. Tucker answered his phone after 1900 hours on the 6th of December 1995, namely the 26 unanswered messages on Mr. Tucker's voicemail, a number of those messages expressing extreme concern about Mr. Tucker's well-being. It appears to be accepted that incoming calls to mobile phone ending 923, which was answered by Mr. Tate, would have appeared in the beacon data for that phone. However, the applicants make a different submission in relation to mobile phone 923. It is alleged that the only reason that the beacon data for mobile phone 923 ended at 1844 was because Essex Police placed time parameters on their request, i.e. they only requested data up until 7 p.m. on the 6th of December 1995. The Commission has been urged to obtain the original application for beacon data in relation to Tate's mobile phone 923. The Commission has sought this application but has been unable to locate it within the files of the Essex Police. The Commission asked Essex Police to comment upon this issue and was provided with the following written response on the 29th of July 2010. Quote, "Although there is evidence within the case papers that cell site beacon evidence was obtained for the mobile telephone of Tate, no application for this data has been identified. This offence was committed pre-RIPA, and as such, single points of contact (SPOC) did not exist, and there was no formalised system for such data applications. Indeed, it is my belief that Essex Police as an organisation had never before used this material either for evidential or intelligence purposes." The most that telephone companies would have requested for was a data protection form, but they would very often provide the information as a result of a verbal request. Although it cannot be stated with certainty, it is possible that this material was provided after a verbal request. The Commission has considered the response of Essex Police on this issue and takes the view that it is reasonable given that there was no formal system for requesting beacon data in December 1995. Although the Commission has been unable to locate any application in respect of beacon data for Mr. Tate's phone 923, the Commission has been able to form a view of the applicant's submission that Essex Police must have placed time parameters on the beacon request. In the context of everything the Commission has seen in the course of its review, it considers it to be highly unlikely that this submission is correct. The Commission notes that the beacon request in respect of Tucker's phone 327 did not include a 1900 time limit, and the billing request data for phone 327 specified the period between 14:51 on the 6th of the 12th and 8 a.m. on the 7th of the 12th. If Essex Police had decided to place time restrictions on requests for data in relation to the victims' phones, it seems inconceivable that they would have neglected to include a time restriction when requesting data for Tucker's phone 327. In support of their submission regarding time restrictions on call data requests, the applicants point out that the witness statement of Barry Dorman states that he called Mr. Tate's mobile phone 923 on the morning of the 7th of December 1995 and it was answered by a woman. This call did not feature in the disclosed beacon data for Tate 923. The applicants submit that this shows that time parameters were placed on the beacon request. The Commission considers that, even if this is true, it does not follow that a 1900 limit was placed on the request. A beacon request, which was in similar terms to the one made for Tucker's phone 327, i.e. data up until 8 a.m. on the 7th of December 1995, an entirely reasonable limit given that this was when the victims' bodies were discovered, would also result in data which omitted the Barry Dorman call, and which also omitted reference to calls which Tate's phone 923 was later found to have received on the 8th, 14th and 18th of December. In further support of their submission regarding time restrictions on call data requests, the applicants seek to rely upon the witness statement of David Yeadle of Orange plc, dated the 7th of August 1997. Mr. Yeadle states that on the 23rd of July 1997 he received a request from Essex Police under Section 28/3 of the Data Protection Act 1984 in relation to Mr. Tate's mobile 923. The request was for call data 10:19 to 18:44 hours on the 6th of December 1995. The Commission has considered Mr Yeadle's statement, but takes the view that the approach by Essex Police, which he described, is likely to relate only to their efforts to place existing call data for Tate 923 in an evidential format which could be relied upon at trial. The Commission understands that Mr Yeadle would have been able to draw on previously retrieved and saved data rather than having to conduct a new search of Orange systems. Issue 3. The allegation that the prosecution manipulated evidence in relation to time of death. Section 67. The applicants have highlighted that Home Office pathologist Dr Lanas did not provide an estimate of time of death when she gave evidence at trial. In her evidence, she stated that the police did not ask her to estimate a time of death. But the applicants point out that Police Action A3680 suggests that she was asked to give an estimate by the Deputy SIO, Detective Inspector George Florence. The applicants add that, since the time of their trial, Dr Lanas has faced disciplinary action in connection with other cases. It is submitted that Dr Lanas was incompetent. The Commission notes that a similar submission was made in the course of Mr Steele's first application to the Commission, application received on the 2nd of February 1999. At paragraphs 107 and 108 of the Commission's Statement of Reasons for that review, dated the 15th of December 2004, the Commission reached the following conclusion on the issue. Quote, "It is Mr Steele's contention that Dr Lanas did determine a time of death, but that, as this was a time for which Mr Steele had an indisputable alibi, Dr Lanas had withheld this time of death from the court. He has pointed to cases that postdate his trial, with which the quality of Dr Lanas's evidence and her competence have been called into question." The Commission notes that Dr Lanas's evidence was that it was not possible to determine the time of death through pathology with any degree of accuracy. There is no evidence to support Mr Steele's contention that she deliberately withheld a time of death because it did not fit the prosecution theory regarding the murders. In the course of the current Commission review, the applicants have submitted no additional evidence or argument on the subject of Dr Lanas. There remains no evidence that Dr Lanas ever carried out any assessment of the likely time of the deaths in this case. Nor is there any evidence that a time of death estimate was deliberately withheld as part of prosecution manipulation of evidence in relation to time of death. The absence of a time of death estimate has been well known since before the applicant's trial and thus does not constitute new evidence or argument for the Commission's purposes. In any event, the absence of a time of death estimate does not, in the Commission's view, give rise to a real possibility that the Court of Appeal would overturn the applicant's convictions. Mr Wombs and Mr Steele's representative, Mr Bowen, has pointed out that the parameters for time of death varied in the public announcements which Essex Police made in December 1995. A police road sign appeal, dated around the 14th of December 1995, stated, quote, "Murder here, PM Wednesday." While LWT's Crime Monthly programme on the 22nd of December 1995 stated that the victims were killed between 1900 and 2100 hours. During his police interview on the 17th of May 1996, Mr Steele was informed that the time of death was around 1900 hours. The Commission has considered this submission and observes that it is entirely understandable that the police's view of the timing of the murders would have been refined over time as the incident room continued to collate information from numerous different sources. Nothing in Mr Bowen's submissions on this issue constitutes evidence that the police manipulated any evidence in relation to time of death. Mr Bowen also pointed out that Detective Superintendent David Bright, in his statement for the Commission's Section 19 investigation, dated the 20th of May 2004, described being informed of the discovery of the victims' bodies at 6:30 AM on the 7th of December 1995, some 90 minutes before the bodies were discovered by Messrs Jiggins and Theobald. Mr Bowen submits that this indicates that the police were aware of the deaths before the discovery of the bodies by Mr Jiggins and Mr Theobald, and this shows that contrary to what the defence have been informed, the victims were under surveillance on the day of the murders. The Commission has contacted former Detective Superintendent Bright and asked him to comment on the reference to 6:30 AM, which appears in his 2004 statement. He responded to the Commission on the 21st of January 2008, explaining that his comment that the call was at 6:30 AM was an approximation. He could not recall who telephoned him, nor could he offer any further explanation for the time discrepancy. In the course of its review of this case, the Commission has discovered no evidence that any police officer was aware of the murders before the discovery of the bodies by Mr. Jiggins and Mr. Theobald. Nor has the Commission discovered any evidence that the victims were under surveillance on the 6th of December. Essex police have confirmed that surveillance of the victims did not take place on the 6th of December. The Commission also notes Mr. Bowen's observation that the surveillance logs for the operation in question make no reference to any surveillance on the 6th of December 1995. The Commission has found no evidence that the police or the prosecution manipulated any evidence in relation to time of death. Consequently, this submission by the applicants does not give rise to a real possibility that their convictions will be overturned by the Court of Appeal. Issue 4. The allegation that the scene of the crime was staged. The applicant submits that the scene of the crime contained fabricated evidence. They highlight the position of spent cartridge shells, the fact that the 8th shell was never found, and the passive nature of the scene. In support of his arguments on this issue, Mr. Steele relies upon his own previous submissions to the Commission and the expert reports of forensic pathologist Dr. Carey and forensic scientist Dr. Renshaw. Mr. Steele submits that it is, quote, not physically possible for the shell case E to land in the glove box through the ejection mechanism of any firearm and can only be the result of being physically placed in position post the murders. The Commission notes that firearms expert Dr. Renshaw appears not to agree with this submission. See page 11 of his report. In any event, the Commission observes that this issue was explored with forensic scientist Mr. Burns at trial and is therefore not new for the Commission's purposes. Mr. Steele also highlights, quote, the anomaly of the spent shell case D, allegedly found in the rear offside footwell of the vehicle that is absent from all photographs taken of the footwell. The Commission observes that this is another point which was explored at trial and so is not new for the Commission's purposes. It was raised with police photographer D.C. King and also D.I. Hughes and D.C. Bettis. In reviewing the applicant's submissions regarding the crime scene, the Commission has considered the expert report by forensic pathologist Dr. Carey, dated the 2nd of August 1997. Dr. Carey's report highlights that the crime scene only contained evidence of 7 shots, all from the same weapon, which is potentially at odds with Mr. Nichols' account that Mr. Steele described 6 shots having been fired from one gun and at least 2 more shots having been fired from another gun. The Commission notes that this argument is supported by firearms expert Dr. Renshaw at page 14 of his report. However, this is another point which was explored at trial and so is not new for the Commission's purposes. The Crown's forensic scientist, Mr. Burns, was of the opinion that all 7 cartridge shells came from the same weapon. In addition, Darren Nichols was cross-examined about his recollection of what he was told about the number of shots which were fired. In any event, the Commission notes that Mr. Nichols was giving an account of what he claimed to have been told by Mr. Steele. Any alleged discrepancies between the scene of the crime and Mr. Nichols' account must be assessed in that context. Mr. Steele's submissions in relation to the scene of the crime include the suggestion that the shotgun cartridge shells may have been planted at the scene of the crime in order to conceal the fact that a different murder weapon was used. Perhaps the firearm which Darren Nichols admitted to purchasing, but which Mr. Steele was acquitted of possessing. The Commission notes that the report of firearms expert Dr. Renshaw does not support this submission. At page 3 of the report, Dr. Renshaw states that, quote, all of the wadding and shot recovered from the bodies of the deceased and the interior of the Range Rover are the same size and type as the wadding and shot which would have been loaded in the 7 cartridge cases. The Commission has not discovered any evidence which suggests that the shotgun cartridge shells were planted at the scene of the crime. Consequently, this submission does not give rise to a real possibility that the convictions would be overturned by the Court of Appeal. Dr. Carey's expert report states his opinion that the murder scene was, quote, rather passive, with the victims all seated normally in their seats and a, quote, relative lack of actively shed blood. Dr. Carey submits this may indicate that the men were already dead or disabled when the shots were fired. The Commission observes that the passive appearance of the scene was an issue which was put to the police officers at trial, and so it does not constitute new evidence or argument for the Commission's purposes. In any event, in the course of the Commission's review, no evidence has been discovered which could support Dr. Carey's theory that the scene of the crime may have been staged. In the absence of such evidence, this submission cannot give rise to a real possibility that the convictions would be overturned by the Court of Appeal. Section 82. In his submissions regarding the scene of the crime, Mr. Steele also observes, after studying the crime scene photographs, that the gate which was in front of the vehicle appears to be capable of being opened without unlocking the chain, as one of the gate posts, quote, appears to be capable of removal from its footing, end quote. Mr. Steele also points out that there appears to be tyre tracks on the opposite side of the gate. The Commission has been provided with images which depict these tracks. It is suggested that the Range Rover may have arrived in Workhouse Lane from this direction. The Commission has considered this theory but considers it to be pure speculation. There is no new evidence to suggest that the Range Rover actually did arrive in Workhouse Lane from the other direction. A further alleged omission from the trial telephone schedule is the call from Craig Rolfe's mobile telephone ending 404 to an unknown telephone number ending 850 made at 11:09 AM on the 6th of December 1995. Once again, the reason that this 11:09 call does not appear in the trial schedule is because that schedule only contained calls between specific telephones listed on the laminated sheet for that exhibit. The number ending 850 was not one of those telephones. In any event, the Commission considers that calls from Rolfe's phone ending 404 on the 6th of December 1995 are irrelevant, as there is no evidence that this telephone was in Rolfe's possession on that day. Further alleged omissions from the trial telephone schedule include a call from Mr. Steele to the Great Bentley Park telephone kiosk on the 11th of November 1995 at 10:06 AM, and a call from the Halfway House telephone kiosk to Mr. Tate on the 5th of December 1995 at 17:03. In both of these instances, the Commission understands that the calls were not included in the trial schedule because the numbers of the kiosks in question were not included on the laminated sheet for that exhibit. The same is true for calls which were made from Tate's landline to the landline of Claire Carey, one of his girlfriends, at 17:15 and 18:06 on the 6th of December. In all instances, the fact of the calls was revealed to the defence in that the relevant billing was disclosed. The applicants further submit that the trial telephone schedule omitted reference to the calls from Mr. Nichols to Mr. Steele on the 5th of November 1995 at 20:46 and from Mr. Nichols to Mr. Steele on the 6th of November 95 at 16:36. The Commission notes that these omissions were raised by Mr. Steele at trial and were agreed by the Crown. The Commission also notes in relation to the 6th of November 1995 call that prosecuting counsel directed Mr. Steele to the telephone schedule which was exhibited under reference JMW 108, which did include the call in question. The Commission does not consider that there is any new evidence in relation to these omitted calls which could give rise to a real possibility that the Court of Appeal would overturn the convictions now. Switching of data. Section 122. It is pointed out that Mr. Steele's call to the BT payphone at Bedloes Avenue, Rolfe at 11:53 on the 11th of November 1995 was in the correct position within an unused trial telephone schedule, but incorrectly appears as the last call of the day in the trial schedule. It is submitted that this difference between the schedules shows that Essex police manipulated the data in an attempt to mislead the jury. The Commission observes that this point was raised by Mr. Steele in his trial evidence, and it was accepted by the Crown that the call appeared in the wrong place in the trial schedule. The Commission also observes that, in his application for leave to appeal in 1998, Mr Steele made the submission that this inaccuracy revealed police misconduct and was aimed at deceiving the trial jury. The submission was considered by the Court of Appeal in January 1999 and so is not new for the Commission's purposes. The same is true of Mr Steele's submission regarding the quote, reversed order of 2 calls timed at 20:39 on the 6th of December, one from Mr Steele's landline to Mr Steele's mobile and the other from his landline to Mr Wome's mobile. Mr Steele's submission that the reversal of these calls in the trial schedule was a deliberate attempt by the Crown to undermine his alibi was before the Court of Appeal in January 1999. The Commission does not consider that there is any new evidence in relation to the quote, switching of data, which could give rise to a real possibility that the Court of Appeal would overturn the convictions now. Attribution of mobile telephones, Section 123. The applicants submit that Essex Police and or the CPS misled the jury by listing in the trial telephone schedules that the Saunders-Tate landline was solely used by Pat Tate and that the Street-Steele landline was solely used by Michael Steele. It is submitted that Miss Saunders and Miss Street were good friends who used to talk on the phone frequently, but the jury was left with the false impression that all of the calls between these 2 numbers were between Mr Tate and Mr Steele. The Commission observes that this point was raised by Mr Steele in his trial evidence. The applicants further submit that Essex Police and or the CPS wrongly attributed mobile phones ending 913 and 404 to Craig Rolfe. It is pointed out that the 2 telephones were actually registered to Mr Rolfe's brother Michael and to Penelope Hughes, Michael Rolfe's partner, respectively. In relation to the phone ending 913, the applicants will be aware that, although this was registered to Michael Rolfe, there was evidence that Craig Rolfe was a user of the phone for a considerable period of time. According to Penelope Hughes' witness statement, S167A, dated the 9th of April 1997, Michael Rolfe had obtained the phone for Craig due to the latter's poor credit rating. Craig Rolfe had used it for 13 months, but had then lost it a matter of days before he was murdered. Craig Rolfe's partner, Donna Jaggers, also confirmed that he had lost his telephone a few days before he was murdered. See police message M184. Throughout its review of this case, the Commission has discovered no evidence to suggest that Craig Rolfe was still in possession of mobile phone 913 on the 6th of December 1995. Nor has the Commission discovered any evidence of calls to or from this telephone after 1900 hours on the 6th of December. In relation to telephone 404, the Commission observes that Penelope Hughes, in her April 1997 witness statement S167A, stated that she was the sole user of this telephone. The applicants submit that the phone was wrongly described as, quote, Rolfe's mobile in the trial telephone schedules, as evidenced by the call made at 12:04 on the 7th of December 1995, after the bodies of the victims had been discovered. Whilst the Commission acknowledges that this call was incorrectly attributed to Mr Rolfe, and the same may be true of other calls in the trial schedule, it does not consider that this point in itself gives rise to a real possibility that the Court of Appeal would overturn the convictions in this case. Point 8. The applicants query why the last dialed number on Mr Tate's landline, according to the memory of the telephone handset, is said to have been Mr Tucker's mobile 327, when the last outgoing call on the 6th of December 1995, according to itemised billing data, was to Miss Carey at 18:06. The applicants submit that the finding of Mr Tucker's number on the handset means that Mr Tate's landline must have called Mr Tucker again after 18:06. They further submit that such a call is most likely to have been made after 2200 that day, as Miss Carey's account was that she was outside Tate's house between 1810 and 2200 hours and Mr Tate was not there. The applicants also make the following arguments in relation to the voicemail for Mr Tucker's mobile 327. Point 1. The fact that he did not answer the incoming call at 1909 on the 6th of December 1995 does, quote, not equate to Tony Tucker being dead and unable to answer his mobile phone, as he may have had his phone turned off or had no network signal or been engaged on another incoming call. Point 2. The 1909 caller did not leave a message for Mr. Tucker, so he would not have received an alert from his voicemail, and this could explain why he did not return the call. Point 3. In any event, searches of the relevant billing data illustrate that Mr. Tucker often failed to respond to messages left on his voicemail. The Commission has considered the applicant's submissions on this issue, which could all have been raised at trial, and takes the view that they add nothing to the evidential position as set out for the jury. It remains the case that there is no evidence that Mr. Tucker made or answered any calls after 1707 on the day in question. Whilst on its own this does not, quote, equate to Tony Tucker being dead and unable to answer his phone at 1909, the absence of any evidence of Mr. Tucker using his telephone after 1909 was a legitimate aspect of the case for the jury to consider. Issue 6. Statement S177, which is alleged to be an undisclosed witness statement by Darren Nichols. It is submitted by the applicants that there exists a witness statement by Darren Nichols which has never been disclosed to the defence and which should be obtained by the Commission now. In the course of its inquiries, the Commission has established that S177 is registered to the Holmes nominal index of Darren Nichols. However, there is no associated document which can be opened when S177 is selected on the system. The Commission's inquiries have also established that there is no witness statement in the paper files of Essex Police which corresponds to S177. Both in the paper files and on the Holmes system, the first statement by Mr. Nichols is the one which was registered as, quote, S177A. According to the record on Holmes, S177 was registered on the 20th of May 1996, and it is described as having been registered in error. Mr. Nichols was in custody on the 20th of May 1996, but did not make his first witness statement until the 21st of May. The question that therefore arises is, how could the police register a statement to Mr. Nichols before they knew that he was going to provide witness evidence? The Commission has considered this matter at length. Essex Police have been asked to provide an explanation, and expert Holmes' opinion has been sought by the Commission in relation to this anomaly. Essex Police have conceded they do not know the definitive answer to this and have considered a number of theories. The Commission has sought to find a technical explanation by considering the potential for there to be an audit record behind the Holmes system which could shed some light on the matter. The Holmes system was upgraded to Holmes 2 sometime after the investigation of this case, and the original Holmes account was converted to Holmes 2 for current access. Holmes 2 has a fully accessible audit system which records all transactions on the account during the period of its usage. Unfortunately, the original Holmes system had no such facility and cannot therefore provide any assistance in this matter. However, at a meeting between the Commission and Essex Police on the 4th of August 2010, a hypothesis was presented that could explain this anomaly. The investigation in this case was managed on two Holmes accounts, one for the drug importation matters and another for the murder investigation. Both ran simultaneously from a common major incident room and they were cross-referenced to each other. This meant that they were searchable, but any data could only be entered onto one of the accounts at a time by separate processes. Statement S21 is not the first interview conducted with Nichols, it is the third. The previous two interviews, dated the 13th and 14th of May 1996, were, quote, no comment interviews. These were not registered until sometime later, the 12th of June 1996. The explanation proffered for this is that S21 was the first interview in which Nichols gave any information regarding the murders and the part he played in it, and the subsequent interviews would have been treated as a higher priority as far as their progress through the MIR system was concerned. The Commission is of the view that this explanation is both credible and logical, and is consistent with the Commission's knowledge and understanding of major incident management and the Holmes system. Issue 7. The allegation that Essex Police colluded with and coached Darren Nichols in his account of events. Mr. Wombs and Mr. Steele's representative, Mr. Bowen, has made numerous submissions which allege that Mr. Nichols was coached in his account of events by Essex Police. In connection with these submissions, Mr. Bowen alleges that the police interviews with Nichols, in which he gave his account of the night of the murders, were not carried out on the 14th of May 1996, as recorded by police, but at a later date. It is submitted that this backdating alone would demonstrate that the investigation was corrupt and the resulting convictions unsafe. It also leaves open the possibility that there were earlier off-tape meetings with Nichols, in the course of which he was coached with a story. The Commission observes that Mr. Bowen has provided voluminous arguments in support of his submission that Nichols' interviews were backdated, but the Commission has seen no evidence which supports this serious allegation. The submission remains unsubstantiated speculation and does not give rise to a real possibility that the Court of Appeal would overturn the convictions in this case. The Commission also notes that Mr. Nichols was represented by a solicitor, Mr. Craddock, at many of the interviews in question. Mr. Craddock has denied both in evidence at trial and in his statement to the Commission's Section 19 investigation in 2004 that there was anything improper about Mr. Nichols' police interviews. In order for the applicant's allegation about backdating to be correct, Mr. Craddock would have had to have been complicit in any impropriety on the part of Essex Police. For the avoidance of doubt, the Commission has discovered no evidence that Mr. Nichols' interviews were conducted in an improper manner, nor has the Commission discovered any evidence that Mr. Craddock has been untruthful in his recollections about the interviews. Mr. Bowen has pointed out that Mr. Craddock was a police officer before he became a solicitor, but the Commission does not consider that this makes it more likely that he has behaved improperly in this case, nor does it mean that Mr. Craddock cannot be trusted in his account. In support of his submission regarding the alleged backdating of interviews, Mr. Bowen relies on Mr. Nichols stating in Interview 7 on the 17th of May 1996 at 10:11 a.m. that, quote, someone had been charged with being in possession of a shotgun, end quote. Mr. Bowen points out that Mr. Steele was not charged with possession of a shotgun until 22:42 on the 17th of May, and so argues that Interview 7 must have taken place after this time and been backdated. The Commission notes that this submission arises from material, namely Mr. Nichols' interview records, which was available at trial, and it could have been utilised in cross-examination of Mr. Nichols and his interviewing officers at that stage. In any event, having considered the submission, the Commission takes the view that there is no real possibility of it leading to the Court of Appeal to find that the interview transcripts for May the 17th were backdated, or that there was anything improper about the way Mr. Nichols' interviews were conducted by Essex Police. In this connection, the Commission notes again that Nichols' solicitor Mr. Craddock was present at all interviews on May the 17th, 1996. As explained above, Mr. Bowen alleges that Nichols' interviewing officers questioned him off-tape. He refers in particular to alleged off-tape discussions on the 16th and 17th of May 1996. This submission arises from cross-referencing Mr. Nichols' custody record for those dates with the transcripts of his police interviews on the 17th of May 1996. These documents were disclosed to the defence at trial and, as pointed out by Mr. Bowen, DC Brown and DC Winston were cross-examined at trial about off-tape conversations with Nichols. The submission is not new for the Commission's purposes and cannot form the basis of a referral to the Court of Appeal in the absence of exceptional circumstances. In any event, the Commission has discovered no evidence that Mr. Nichols was ever coached in his account by Essex Police. The Commission notes that Mr. Nichols' solicitor, Mr. Craddock, has stated that as far as he is aware, Mr. Nichols was never coached or spoken to off tape regarding his account of events. However, Mr. Bowen submits that Mr. Craddock's statement for the Section 19 investigation actually supports the submission that Mr. Nichols was interviewed off tape. Mr. Bowen highlights page 5 of the statement, where Mr. Craddock describes the interviewing officers asking Mr. Nichols, quote, various questions about what mobile telephone he was using at the time of the offences and as to whether he was carrying it and whether it would have been turned on or off, end quote. Mr. Bowen states that such questions do not appear anywhere in the Nichols interview transcripts, and that this supports his submission that Mr. Nichols must have been questioned off tape. The Commission does not consider this submission to be correct. In the Commission's view, the line of police questioning, which appears at pages 15 to 21, page 19 in particular, of the interview transcript for the 17th of May 1996 at 16:38 hours, contains the quote, various questions about what mobile telephone Mr. Nichols was using at the time of the offences, end quote, which are referred to in Mr. Craddock's statement. There is no real possibility in the Commission's view that a Court of Appeal would find Mr. Craddock's statement to support the submission that Mr. Nichols was spoken to off tape. In any event, Mr. Craddock's Section 19 statement was available to the applicants and to the Court of Appeal in 2006, and it was open to the applicants to pursue this point at that stage. In further support of the submission that Mr. Nichols was spoken to off tape by Essex Police, Mr. Bowen has drawn the Commission's attention to a faxed summary of the case against the applicants, faxed on the 22nd of May 1996. This summary refers to the details of the events of the 6th of December purportedly obtained from Mr. Nichols, but which do not appear in Mr. Nichols' answers during police interview. In particular, Mr. Bowen refers to references to a quote, blue Range Rover and an allegation by Mr. Nichols that Mr. Steele had referred to Mr. Wombs as a quote, evil cunt when describing the killings. Neither of these points appear in Mr. Nichols' police interviews, which simply refer to a quote, Range Rover and Mr. Steele's alleged comment that Mr. Wombs was a cold-hearted bastard, end quote. Mr. Bowen adds that references to a blue Range Rover do appear in the briefing notes of D.C. Shakespeare, 16th of May 1996, and that D.C. Shakespeare repeated, quote, blue Range Rover when putting Mr. Nichols' account to Mr. Steele in interview on the 17th of May. Furthermore, according to Mr. Bowen's note, prosecuting counsel John Butcher referred to Mr. Nichols' description of a quote, blue Range Rover when summarising the case at the first remand hearing at Chelmsford Magistrates Court on the 18th of May 1996. Mr. Bowen submits that, since these words didn't come from Mr. Nichols in the disclosed police interviews, Mr. Nichols must have discussed the case with officers off tape or in recorded interviews which have not been disclosed. Mr. Bowen also points out that the vehicle is referred to as a quote, dark Range Rover in police summary document D56. Mr. Bowen submits that Essex Police attempted to cure these discrepancies over vehicle colour by coaching Mr. Nichols to refer to a quote, dark coloured or blue Range Rover in his witness statement S177A. Mr. Bowen also submits that Essex Police removed the anonymous reference to Mr. Steele describing Mr. Wombs as a quote, evil cunt when the case was summarised in police document D56. Mr. Bowen relies upon the fact that the text in D56 reads, quote, a cold-hearted bastard, which suggests that the text has been amended. The fact summary that Mr. Bowen seeks to rely upon appears to be part of the faxed history of Mr. Steele as provided by Essex Police for the benefit of the prison authorities. This summary would have had no evidential standing whatsoever, as opposed to Mr. Nichols' account of events as given in police interview and then in evidence at trial. In any event, whilst the discrepancies which Mr. Bowen highlights may indicate that Mr. Nichols has been misquoted in the faxed summary, this does not necessarily indicate that Mr. Nichols gave a conflicting account off tape. The same is true of the reference to the colour of the victim's Range Rover. The colour of the vehicle which was discovered in Workhouse Lane would have been well known to police officers dealing with the case, and the inclusion of the word blue is far more likely to be an error on their part rather than an indication that Mr. Nichols gave further details off tape. In all of the circumstances, the Commission takes the view that Mr. Bowen's submissions on this issue do not give rise to a real possibility that a Court of Appeal would find that Mr. Nichols was spoken to off tape and coached in his account. In support of his allegation that interview records have been fabricated, Mr. Bowen queries why, quote, error reference source not found, end quote, appears at the top of each page of certain Nichols interview transcripts. The Commission understands that this error message occurs when a form field is deleted rather than written within the normal way. This error message does not constitute evidence that Essex Police fabricated evidence. Point 2. The applicants submit that Essex Police's interrogation of the victim's mobile phone handsets was inadequate, particularly the attempts to interrogate Mr. Tucker's handset, of which DC Miller stated, quote, "I was unable to power up the telephone due to heavy blood contamination. I was therefore unable to extract any information from the telephone." End quote. As a result of this submission, the Commission arranged for the handsets attributed to Mr. Tucker and Mr. Tate, together with their associated SIM cards, to be interrogated using modern mobile phone forensic techniques. The testing was carried out by Dr. James Luck, Senior Technologist at the Metropolitan Police Digital and Electronics Forensic Service. Dr. Luck provided his results to the Commission on the 19th of April 2010, and they were disclosed to the applicants on the 6th of May 2010. Dr. Luck's interrogation resulted in the retrieval from the memory of each of the two handsets of the telephone numbers for dialed, received and missed calls, although he could not definitively say which category of call each of the numbers fell into. Unfortunately, Dr. Luck confirmed that neither of the handsets was capable of storing the times or dates of the calls. In those circumstances, the Commission does not consider that the results of Dr. Luck's interrogation are capable of assisting in a determination of whether either of the victims made or answered telephone calls after 1844 on the 6th of December 1995. Having received Dr. Luck's results, the Commission considered that the only conceivable way of making further inquiries into the dates and times for the dialed and received calls to and from the victims' mobile phones would be to analyse the itemised billing data for each of the telephone numbers which were retrieved from the memory of the handsets. Consequently, the Commission has analysed itemised billing for the following telephone numbers attributed to Paul Edwards, Donna Jaggers, the telephone kiosk at the Halfway House, Basildon Tyre Services, the payphone near to the Sorrel Horse Public House in Barham, Ipswich, Tucker's home number, and the phone attributed to Michael Bowman. None of the itemised billing which has been analysed has revealed any post-1844 calls to either of the relevant victims. The Commission has been unable to locate any itemised billing data for the following telephone numbers, the remaining numbers retrieved from the handsets by Dr. Luck. Numbers attributed to Craig Rolfe's mother, the payphone of the Oasis Public House in Basildon, phones attributed to Barry Dorman, Ray Sullivan, Donna Garwood, Paul Chavou, Donna Garwood's mother, and Donna Garwood's work number. Having considered all of the available data, and the representations of Mr. Wombs, Mr. Steele and Mr. Bowen on this issue, the Commission takes the following view. There remains no evidence of any calls made or answered by any of the victims after the 1844 call. Point 3. The applicants have referred to the two phone calls made by Mr. Steele to Mr. Wombs at 1803 and 1809 on the 6th of December 1995. It is pointed out that the Crown claimed that the calls were made from the car park of the Halfway House Public House. However, both of the calls were served by the Childerditch Beacon, and it is said that this would not have been possible if they had been made from the Halfway House. The Commission observes that this point was analysed at trial. It also featured in Mr. Steele's grounds of appeal for the 1999 application to the Court of Appeal, and in David Bristow's expert report for the 2006 appeal to the Court of Appeal. The submission is therefore not new for the Commission's purposes, and cannot form the basis of a referral to the Court of Appeal. Point 4. It is submitted that Mr. Bristow's tests have now proved that it would have been impossible for Mr. Tate to receive the 1844 call from Sarah Saunders via the Wickford transmitter if he was located in or near to Workhouse Lane at that time. This submission would appear to be based upon testing which Mr. Bristow carried out prior to trial in 1997. Quote, "More recently, I have carried out further analysis and tests on the service provided by cell identity 1404 from the Orange cell site, i.e. Wickford." End quote. However, Mr. Bristow does not give any specific details of the quote, "further analysis and tests" that he has carried out. except to mention that he has carried out a quote study of the topography, which shows that there is no line of sight path between the Wickford cell site and any part of Workhouse Lane. The Commission does not consider that there is any new evidence on this point which was not available at the time of the trial in 1997 and at the time of the appeals to the Court of Appeal in 1999 and 2006. In any event, although Mr Bristow was not able to pick up the Wickford transmitter when he carried out tests in Workhouse Lane in September 1997, the Commission does not consider that this shows that it would have been impossible for Tate's phone to have picked up the Wickford transmitter in December 1995. The Commission observes that, point 1, it was recognised at trial and then again before the Court of Appeal in 2006 that it was extremely difficult to replicate the exact conditions which would have existed for mobile phone usage in the area in question on the evening of December 6, 1995. As the Court of Appeal explained in 2006, quote, "It is exceedingly difficult to identify the variable conditions prevailing on any particular previous occasion. Thus, one cannot say whether any particular call is more likely to be routed to one cell site than another. All that can be said is whether it is possible for it to have happened." Point 2. When giving evidence at trial, Mr Bristow acknowledged that variations in any of the following factors might have had some effect on which beacons calls were routed through on separate occasions. Erection of buildings, growth of foliage, the type of handset used, the orientation of the handset during the call including position within a vehicle, the presence of other motor vehicles, the prevailing weather conditions, the precise geographical position and elevation above the ground. Mr Bristow added, quote, "I'm the first to admit that mobile phone evidence of this kind is an imprecise art." Point 3. On appeal in 2006, the Court of Appeal emphasised another important variable, namely, quote, "Each cell site has only so many available channels. If all the channels on the cell site are being used by other callers, then the computers will automatically switch the call to another cell site. Thus, whether a call is routed to one cell site or another will be affected by the volume of telephone traffic at that particular time. Volume of telephone traffic is variable and unpredictable, but is often at its heaviest during the evening rush hour." Point 4. When giving evidence at trial, Simon Collins, a telephone expert called by the prosecution, stated, quote, "Trying to plot where people are by mobile telephone evidence is near enough impossible. You are dealing with likelihood and possibilities, and it is very complicated. See page 14 of transcript of summing up for the 14th of January 1998. For all of these reasons, the Commission does not consider there to be a real possibility that the Court of Appeal would find it to have been impossible for Mr Tate to have received the 1844 call via the Wickford transmitter if he was in Workhouse Lane at the time, even if Mr Bristow's opinion regarding the 1844 call were accepted. However, the Commission does not consider that this would advance matters significantly. Mr Bristow's conclusion in relation to the 1844 call is the following, quote, "When Pat Tate received the call from Sarah Saunders at 1844, he might possibly have been in the Rettendon area, but he could not have been in Workhouse Lane, either at the beginning of the call or at the end of the call." The Commission takes the view that, even if Mr Bristow were correct that Mr Tate was in, quote, "the Rettendon area," rather than specifically Workhouse Lane, at the time of the 1844 call, this would not raise a real possibility that the Court of Appeal would overturn the convictions. The Commission acknowledges that Mr Nichols' trial evidence was that Mr Steele told him Mr Tate took the 1844 call when they were in the lane. But the Commission notes once again that Mr Nichols was giving a, quote, "second-hand account of what he claimed to have been told by Mr Steele, and any alleged discrepancies must be assessed in that context." Issue 8. The submission that Nichols has embroidered his account at various stages throughout the history of this case. The applicant submits that a comparison of Mr Nichols' statements to the police, his evidence at trial, the TV documentary he helped to make, Mr. Thompson's book Blogs 19, and the statements taken from Mr. Nichols during the Commission's Section 19 investigation provides ample evidence to attack the veracity of Mr. Nichols' trial evidence. It is further submitted that, if these materials had been available at trial, they would have constituted vital sources of cross-examination. The applicant states that a key example of Mr. Nichols' willingness to embroider his account can be found in his description of picking up Mr. Steele and Mr. Womes from the scene of the murders. His police interviews, witness statements and evidence to the trial jury included the following description. Quote, "When the interior light came on, I noticed that Jack was wearing surgical type gloves and that they were speckled with red." End quote. The applicants invite the Commission to compare this to Mr. Nichols' account to Tony Thompson as related at page 139 of the book Blogs 19, where the description reads, quote, "And that's when I saw Jack's hands. He was wearing surgical gloves, and they'd been splashed with streaks of blood, and on the back of one hand was a lump of greyish slime surrounded by lumps of hair and skin and more blood." End quote. It is submitted that the Blogs 19 description is an embellished version of Nichols' trial account. The applicants add that, even before Mr. Nichols' witness statement of the 20th of August 1996, he gave an embellished account to the media. In the joint proposal, which was faxed from Tony Thompson to Caroline Dorney on the 29th of July 1996, Mr. Nichols is quoted as saying, "Then I could see them for the first time, just for a second. They were both absolutely covered in bits of flesh and skin." End quote. It is submitted that Mr. Nichols' accounts to the media involving descriptions of, quote, "streaks of blood and bits of flesh and skin" reveal the Commission to have erred in its conclusion where it stated, quote, "There is no evidence or information to suggest that Mr. Nichols had been prepared to embroider his account in order to enhance the value of his story." See paragraph 62 of Statement of Reasons in relation to Mr. Steele, 15th of December 2004. In addition, the applicants submit that Mr. Nichols admitted to Tony Thompson that he had given perjured evidence at trial about Francis Reed. It is noted that Mr. Nichols later denied this to the Commission's Section 19 inquiry. It is further submitted that Mr. Nichols gave contradictory accounts to the police compared to his account in Blogs 19 about why he became involved in crime with Mr. Steele and Mr. Womes and why he formed a relationship with DC Bird. The applicants argued there is no sense in Mr. Nichols' account, as relayed in Blogs 19, that he was a reluctant or duped participant in the criminal enterprises. Nor is there any sense that he cooperated with DC Bird because he was desperate to stop Mr. Steele and Mr. Womes from forcing him to commit crimes. The Commission has considered all of these submissions, but takes the view that they relate to matters which were before the Court of Appeal in 2006. Both Blogs 19 and the joint proposal were available to the applicants and to the Court of Appeal at that stage, and the Commission cannot see what is new on this point which could form the basis of a second referral to the Court. In any event, whilst Mr. Nichols' accounts to the media do arguably reveal a willingness by Mr. Nichols to embellish his account, in the sense of making it more gory or sensationalist, or including bravado about his relationship with Mr. Steele, Mr. Womes and DC Bird, the descriptions to the media still do not reveal Mr. Nichols to have ever contradicted himself in the essential aspects of his account. Issue 9. The submission that Essex police were complicit in Nichols' meetings with the media. The Commission takes the view that there is no new evidence on this issue which was not before the Court of Appeal in 2006. The applicants seek to rely upon an entry in Mr. Nichols' custody record which shows that Mr. Nichols was accompanied by DC Brown on the 14th of September 1996, which was the day that Mr. Nichols signed his first contract with the media. The Commission observes that the relevant sections of the custody record were disclosed partway through the applicant's trial, and the sections were also before the Court of Appeal in 2006. They do not constitute new evidence or argument for the Commission's purposes. As part of their submission that Essex police were complicit in Mr. Nichols' dealings with the media, The applicants claim that the conditions of Mr Nichols' bail were varied in July or early August 1996 to enable him to travel to London to meet with media contacts. It is suggested that the bail variation involved the removal of the condition that Mr Nichols, quote, live and sleep at a police station designated by the senior investigating officer. A photocopied page from the Rettendon inquiry is relied upon, which reveals part of an underlying bail notice. The applicants have suggested that this bail notice relates to Darren Nichols. It is submitted that the police must have sought unconditional bail for Mr Nichols in case he was seen on his own at any point during the trip to London on the 1st of August. The secret grant of unconditional bail would have provided the police with an instant answer to any critics. It is further submitted that, if Mr Nichols was on unconditional bail after the 24th of July 1996, this would make a fiction of his custody record, DC Brown's notebook, and the trial and appeal evidence of DC's Brown and Winston. In the course of its inquiries, the Commission has located the bail notice, which can be seen in part on the photocopied page from the police policy file. A redacted version of the notice was disclosed to the applicants on the 9th of August 2010. As the Commission confirmed at that stage, the bail notice does not relate to Darren Nichols. The Commission has discovered no evidence to support the applicant's allegation that the conditions of Mr Nichols' bail were varied in July or August 1996. In any event, the Commission does not consider that a bail variation would be required in order for Mr Nichols to attend a meeting in London. The SIO could have designated a police station in London for Mr Nichols to reside at on the day in question. Issues 1. New witness Mr W. Section 45. A new witness, Mr W, has made a statement that he saw a metallic blue Range Rover in the vicinity of the Rettendon Turnpike at 2300 to 23:45 hours on the 6th of December 1995. There were two men in the front seats of the vehicle, and one large man seated in the rear. Given that the victims were driving a blue Range Rover on the evening of their disappearance, and their bodies were discovered in the same vehicle, the applicants submit that Mr W's statement constitutes significant new evidence which assists in determining the time of their deaths. It is submitted that Mr W's account undermines the evidence of Darren Nichols that the murders took place at around 1900 hours on the 6th of December 1995 and provides support for the trial evidence of William Jasper and Stephen Rogers, which indicated that the murders may have taken place at around midnight that night. Section 46. The Commission was provided with Mr W's witness statement on the 31st of October 2007. Having considered that statement and the preceding interviews conducted by Jeff Kelly and Christopher Bowen on the 18th of May 2007, the Commission took witness statements from Mr W's wife, Mrs W, on the 29th of January 2008 and from Mr W's friend, Mr T, on the 26th of March 2008. Those statements are disclosed at Annex B of this Provisional Statement of Reasons. Section 47. Mrs W describes an occasion in late 1995 when she and her husband were watching the lunchtime news on the television when a news report stated that the bodies of three men had been discovered in a Range Rover somewhere in Essex. Mrs W remembers her husband pointing to the television and saying, quote, "That's the same Range Rover. That is it. That's the one that cut us up." Mr T describes an incident which he believes to have taken place sometime between 11 p.m. and midnight on the night before he became aware of the Rettendon murders in 1995, when he was the passenger in Mr W's vehicle as it was cut up by a larger 4x4 style vehicle. There were three men in the 4x4, one of whom was a very large man sitting in the rear of the vehicle. Mr T does not know where this incident took place. Section 48. The Commission has considered Mr W's account in the context of those given by various other witnesses in the case. In addition to the statements of Mrs. W and Mr. T, the Commission has considered the witness statements and, where applicable, the trial evidence of Michael Stenning, Andrew Reynolds, Raymond Wright, Ian Williams, Kevin Tarbuck, Stuart Armstrong, William Jasper, Stephen Rogers, Stephen Hills, Peter Theobald, Kenneth Jiggins and P.C. Knights. Although none of these accounts constitutes new evidence for the Commission's purposes, see page 2, paragraph above, they have all been reconsidered in the light of the new statements by Mr. and Mrs. W and Mr. T. The Commission has paid particular attention to the accounts of William Jasper and Stephen Rogers. Mr. Jasper gave evidence at trial that he drove the murderer, who was not Mr. Steele, Mr. Wombs or Mr. Nichols, to Rectory Lane, which is near to the scene of the murders at around midnight on the night of the 6th/7th of December 1995. Mr. Rogers gave evidence at trial that he heard a rapid series of gunshots, more than 2, at around midnight on the night of the 6th/7th of December 1995. Section 49. The Commission has considered whether or not the information provided by Mr. W, Mrs. W and Mr. T gives rise to a real possibility that the Court of Appeal would overturn the convictions in this case. Whether the evidence appears to be capable of belief. Section 51. The Commission considers that, in general terms, the accounts given by Mr. and Mrs. W and Mr. T, i.e. that Mr. W was involved in an incident with a Range Rover in the Rettendon area in December 1995, are plausible. However, in assessing the view that the Court of Appeal would be likely to take of the credibility of their proposed new evidence, the Commission has considered the following points. Point number 1. Despite public appeals for information soon after the murders, which all 3 witnesses concede that they were aware of, none of the witnesses volunteered their information to the authorities at the time. It was only 11 years later, following a fortuitous conversation between Mrs. W and Mr. Bowen, that these witnesses agreed to provide their information. When asked why they had never come forward previously, all 3 individuals stated they did not consider it to be relevant to the Rettendon murder inquiry. If this case were referred, the Court of Appeal would need to decide whether it considered this to be a plausible explanation for the 11-year delay in coming forward. The Court's decision on this issue would be likely to influence its overall view of the credibility of what the proposed new witnesses have to say. Point number 2. In Mr. W's witness statement, dated the 12th of August 2007, there is no mention of the registration number of the Range Rover which he saw in December 1995. However, in interview on the 18th of May 2007, Mr. W stated that he could remember that there were 2 4s in the registration number. He confirmed that he did not write down any details from the registration number at the time of the incident. He also confirmed that he had seen the registration plate in television footage subsequent to the murders. If this case were referred, the Court of Appeal would have to consider the credibility of Mr. W's claim to have remembered 2 4s in the registration number in the context of the fact that he did not make any note of the number and then subsequently saw the full registration number pictured in television footage. Point 3. In interview on the 18th of May 2007, Mr. W described the rear seat passenger wearing a white t-shirt. The Commission observes that Mr. Tate was not wearing a white t-shirt on the night in question, and nor were the other 2 victims. However, a photograph of Mr. Tate was shown during subsequent television news coverage of the murders, which depicted Mr. Tate wearing a white t-shirt. The Commission considers that Mr. W's assertion implies that at least some of his account may have originated from the television news coverage of the murders. Point 4. The Commission also notes that a comparison of Mr. W's statement with that of his wife reveals an inconsistency in their accounts. Page 5 of Mrs. W's statement includes the following comment, quote, I also remember that when my husband first mentioned this to me when we saw it on the TV, that he remembered the end of the lane being taped off by the police, and he had seen this when he drove home the same way. That helped him put two and two together. The latest he would have arrived home would have been between 7 and 8 a.m. The Commission observes that the victims' bodies were discovered just before 8 a.m. on the 7th of December 1995, so it seems unlikely that he could have seen the lane being taped off by police when on his way home from work. At page 3 of his statement, Mr. W states, quote, "My work finished at around 6 a.m. on Thursday the 7th of December 1995. Nothing of note occurred during my return journey, which was the outbound journey in reverse. I got home at around 7:30 to 8 a.m. and went to bed." The Commission considers that this inconsistency is another which would be likely to affect the Court of Appeal's view of the credibility of the accounts given by Mr. and Mrs. W. Section 52. Having considered these points, the Commission observes that there are a number of reasons why the Court of Appeal might decide that the proposed new evidence is not capable of belief. However, it has not been necessary for the Commission to reach a concluded view on this matter in the light of paragraphs 53 and 54 below. Whether the evidence may afford any ground for allowing the appeal. Section 53. The Commission observes that Mr. W's account, taken at its highest, is that he saw a blue Range Rover containing 3 male passengers in the vicinity of the Rettendon Turnpike at 2300 to 23:45 hours on the 6th of December 1995. Even if this evidence were accepted by the Court of Appeal, the Court would still need to assess whether it might afford a ground for allowing an appeal. Having considered the accounts of Mr. W, Mrs. W and Mr. T, the Commission does not consider that there is a real possibility that the Court of Appeal would conclude that they provide strong enough evidence to afford a ground for allowing an appeal. The Commission notes in particular that Mr. W describes a Range Rover approaching the Rettendon Turnpike from the north and turning left, i.e. east, towards South Woodham Ferrers. It appears, therefore, that the vehicle had already passed the entrance to Workhouse Lane when it was seen by Mr. W. It follows that if it were the victim's vehicle, the Range Rover would either have to turn around and go back to Workhouse Lane via the old A130, or travel to Workhouse Lane via Rectory Lane and cross the fields of White House Farm. The Commission considers the latter scenario to be highly unlikely, as it would have involved crossing the fields, lifting the locked gate out of its footing, turning the Range Rover around in the lane for no obvious reason, and then replacing the locked gate into its footing. Mr. W says he saw a Range Rover at 2300 to 23:45 hours on the night in question, and it must follow from that the occupants of the vehicle were at liberty at that stage. If this were the victim's Range Rover, it leaves more than 4 hours unaccounted for in terms of their movements on the evening in question. No explanation has been found for why the victims did not attend their dinner at the Global Net Cafe, or for the fact that they did not make any telephone calls even to explain where they were. Doubts remain over those aspects of Mr. W's account which appear to link the incident which he describes to the victim's Range Rover, i.e. his partial memory of the registration number and his memory that the rear passenger wore a white t-shirt, see paragraph 51 above. The witness statement of Mr. T does not add anything of substance to the statements of Mr. and Mrs. W. Section 54. For the reasons given above, the Commission takes the view that there is no real possibility that the Court of Appeal would find the proposed new evidence to afford a ground for allowing an appeal in this case. There is no real possibility, in the Commission's view, that the Court would conclude that the proposed evidence might reasonably have affected the decision of the jury to convict if it had been heard at trial. Conclusion in relation to the witness statements of Mr. W, Mrs. W and Mr. T. Section 55. For the reasons given at paragraphs 51 to 53 above, the Commission does not consider that there is a real possibility that the Court of Appeal will think it is necessary or expedient in the interest of justice to receive the proposed evidence of Mr. W, Mrs. W and Mr. T. Consequently, the applicant's submission in relation to Mr. W does not give rise to a real possibility that the Court of Appeal would overturn the convictions in this case. Issue 2. Expert Report by Mr. Roonacres, Section 56. As explained at paragraph 48 above, the Commission has considered Mr. W's new statement in the context of a number of trial witnesses, including Mr. Peter Theobald, who discovered the Range Rover just before 8 AM on the 7th of December 1995. In view of the fact that there was no snow or frost on the vehicle, Mr. Theobald testified that he had formed and remained of the opinion that the Range Rover had not been in the lane overnight. This aspect of Mr. Theobald's trial evidence thus contradicted Darren Nicholls' account that the Range Rover had been in the lane since around 7 PM on the 6th of December 1995. Having considered Mr. Theobald's evidence, the Commission decided to seek expert advice on the question of whether or not the absence of snow and frost from the surfaces of the vehicle could give any useful indication as to how long it had been situated in Workhouse Lane before being discovered. The Commission wished to discover whether expert evidence might offer support for the proposition that the victim's Range Rover arrived in the lane far later than claimed by Darren Nicholls, and as suggested by the statement of Mr. W and the trial evidence of William Jasper, Stephen Rogers and Peter Theobald. On the 29th of September 2009, the Commission instructed forensic meteorologist Mr. Roonacres to provide his expert opinion. The Commission asked Mr. Roonacres to complete a comprehensive search of all available sources which could establish the prevailing weather conditions for Workhouse Lane on the 6th and 7th of December 1995. The Commission also asked Mr. Roonacres to provide his expert opinion on how long he believed the Range Rover had been in Workhouse Lane by the time it was discovered just before 8 AM on the 7th of December. Finally, the Commission asked Mr. Roonacres for his expert opinion as to how he would expect a vehicle to appear which had been stationary in Workhouse Lane between 7 PM on the 6th of December and 8 AM on the 7th. Mr. Roonacres' expert report was received by the Commission on the 20th of April 2010. In relation to the absence of snow on the Range Rover, Mr. Roonacres concluded, quote, "It appears likely, although I cannot be certain, that no snowfall occurred after approximately 1700 hours on Wednesday the 6th of December 1995. It is clear from the witness evidence that the Range Rover must have arrived at Workhouse Lane after that time. Therefore, the lack of lying snow on the vehicle at the time it was discovered does not assist in determining the arrival time of the Range Rover." In relation to the absence of frost on the Range Rover, Mr. Roonacres concluded, quote, "Despite the shelter effects of the hedgerows and trees, as a result of the sub-zero air temperatures and relatively high humidities overnight and during the early morning hours, I would expect any vehicle that had been stationary in Workhouse Lane for a prolonged period of time prior to 8 AM on Thursday the 7th of December to have exhibited a hoar frost on its external surfaces. I cannot determine the precise length of time that would have been required for a hoar frost to form on the external surfaces of the Range Rover after it had arrived in Workhouse Lane and its ignition switched off. However, in my opinion, I consider it likely that this would not have required more than a few hours or so. Assuming the Range Rover was left undisturbed, I am currently unable to explain this apparent anomaly when compared to the prosecution case, that the Range Rover arrived at the incident scene at approximately 1900 hours on Wednesday the 6th of December. Mr. Roonacres' report was disclosed to the applicants on the 6th of May 2010. Having considered the report, Mr. Steele has stated that he believes Mr. Roonacres' findings to be seriously flawed. He does not wish the Commission to rely on any of Mr. Roonacres' conclusions. Mr. Steele questions whether Mr. Roonacres is suitably qualified to offer an expert opinion, since he possesses no qualification in the science of meteorology. Mr. Steele also points out that, in any event, meteorology is an inexact science. Mr. Steele disagrees with Mr. Roonacres on the following points. Mr. Steele disagrees with the conclusion that it is, quote, "likely that no snowfall occurred after approximately 1700 hours on Wednesday the 6th of December. He points out that 2 witnesses described it snowing in the vicinity of the scene of the crime after 1700 hours on the day in question. Kevin Tarbuck stated it was snowing at 1950, statement S51 dated the 14th of December, and Ian Williams stated that it started snowing lightly just before 2030 hours, statement S73 dated the 19th of December 1995. Mr. Steele states that a heavy vehicle like the Range Rover would have left tyre tracks, and the absence of these can only be explained by their being covered with snow after the vehicle arrived. The absence of snow on the vehicle can also be explained by the warmth of its surfaces when it arrived at the scene, and or a coating of glycol antifreeze which Mr. Steele suggests had recently been applied to the vehicle. The Commission notes that if Mr. Steele is correct in this observation, then this further undermines the defence proposition that the absence of frost on the Range Rover indicated that it had not been in Workhouse Lane overnight. Mr. Steele disagrees with the conclusion that it, quote, would not have required more than a few hours or so for a hoarfrost to form on the external surfaces of the Range Rover after it had arrived in Workhouse Lane and its ignition switched off. Mr. Steele states that the absence of frost can be accounted for by the shelter which was provided by the surrounding foliage and or a coating of glycol antifreeze. Mr. Womes has also considered Mr. Roonacre's report and has provided his own observations. Like Mr. Steele, Mr. Womes disagrees with Mr. Roonacre's on the subject of snow, pointing out that there must have been snowfall after the arrival of the Range Rover because Mr. Jiggins stated at trial that on the morning of the 7th of December, quote, there was a lot of snow and ice over the puddles, and none of the ice had been broken. The Commission notes conversely that the fact that the ice not having been broken suggests that the Range Rover may well have been in a lane for some time. On the subject of frost, Mr. Womes submits that Mr. Roonacre's report provides support for his case in that it confirms the lay opinion of Mr. Theobald that he would have expected there to be frost on the Range Rover if it had been in Workhouse Lane overnight. The Commission has considered Mr. Roonacre's expert report together with observations of Mr. Steele and Mr. Womes. The Commission takes the view that the report adds nothing of any substance to the position as it was at trial in relation to the absence of frost and snow on the Range Rover, nor does the Commission consider that Mr. Roonacre's report assists as regards the proposition that the shootings may have occurred at around midnight on the night in question. It does not provide any support, therefore, for the statements of Mr. W, Mrs. W and Mr. T. The Commission has reached the view that Mr. Roonacre's expert opinion is not capable of giving rise to a real possibility that the Court of Appeal would overturn the convictions in this case. In the light of this view, the Commission has decided not to revert to Mr. Roonacre's for his comment on the points raised by Mr. Steele and Mr. Womes. Point 7. The applicants submit that the Court of Appeal was wrong to state in February 2006 that cell site evidence provided compelling evidence for Nichols' version of events, as Nichols, quote, did not and could not have known about the cell site data when he gave his account to police. The Commission has considered this submission, but has discovered no evidence which suggests that Essex Police revealed cell site data to Mr. Nichols before he gave his account. Whilst it is clear that Mr. Nichols was asked questions about itemised billing in police interview, the Commission has seen no evidence that police revealed cell site data to him. The Crown disclosed at trial that Mr. Nichols' interviewing officers had worked from an action pack which was in the form of a call schedule drawn up from the itemised billing, but there was no suggestion that this included cell site data. The Commission notes that Mr. Nichols was cross-examined at trial about the nature of the telephone data that he was shown in police interview. In making their submission about Mr. Nichols' knowledge of cell site data, the applicants seek to rely upon David Bristow's expert report of June-October 2007 at paragraph 5.1, where Mr. Bristow points out that Essex Police obtained the relevant cell site data almost 5 months before Nichols was interviewed. The Commission acknowledges that this appears to be correct, but it does not follow from it that the data was shown to Nichols before he gave his account. In further support of the submission regarding Mr. Nichols' knowledge of cell site data, Mr. Wombs and Mr. Steele's legal representative, Mr. Bowen, relies upon the transcript of the Section 19 inquiry interview with DC Winston, which took place on the 30th of March 2004. At page 31 of the transcript of the first interview, the following exchange took place. Question: did you at any time coach Nichols so that his evidence matched the cell site analysis that you're aware of? Answer: no, definitely not. Question: was he ever made aware of the results of the cell site evidence that you're aware of? Answer: I don't know, sir. I don't believe I've made him aware. Question: was the knowledge of the cell site analysis part of your interview then? Answer: yes, it would have been at some point, yeah. The Commission has considered these responses by DC Winston in the context of his earlier answers in the interview. See pages 24 to 26 of transcript of the first interview. Question: when you started those interviews, when Nichols started to speak about the murders, in terms of locations and all the things that happened, can you remember what your depth of knowledge was as a previous member of the investigation team regarding the in-depth matters of those investigations? Like a good example is cell site analysis and that type of thing, or when Nichols started to speak to you, was it effectively fresh to you? He's given you locations and the route in and the route out and everything. Was that completely new to you? Answer: yeah, to the best of my knowledge, it was completely fresh to me at that stage. Question: right, so things like the in-depth, bearing in mind you've got a homes inside team doing loads of work, and then you've got the outside teams, and bearing in mind you would have briefings fairly regularly. Things like cell site analysis is the best example I can think of. Would you have known the in-depth detail of what was going on elsewhere in the investigation? Answer: we may have had an overview, but the cell site analysis, I'm not sure that I knew all the details, which I could recall now that was done by a specific set of people. And I don't recall being specifically told results of all the analysis. I don't recall the specific details of cell site analysis on specific phones. The Commission notes that DC Winston was cross-examined at trial about the use of telephone data when interviewing Mr. Nichols. Question: when you were interviewing Mr. Nichols, did you have in front of you and available for him to look at various documents? Answer: on some occasions, I believe. Question: so let me give you some examples. Did you have telephone toll tickets, in other words, the record of calls made between the various people in this case? Answer: yes, sir. Question: you see, were you in fact using document toll tickets to assist Mr. Nichols in getting a cohesive story together? Answer: the only reason documents were used was to prove or disprove what Mr. Nichols was telling us. The Commission also notes that DC Brown, the police officer who interviewed Mr. Nichols alongside DC Winston, was questioned at trial about the telephone data which was used in the Nichols interviews. Although he acknowledged that an interview pack was used which contained call data, DC Brown denied that any call data was, quote, fed to Mr. Nichols before he gave his account of events. The Commission also notes the witness statement given to the Section 19 inquiry by Lee Craddock, who represented Mr. Nichols during many of his police interviews. At page 5 of the statement, Mr. Craddock stated, "It was only some time later, i.e. after the police interviews, that I became aware that the police were to use cell site analysis to plot the movements of mobile telephones. At the time, I did not know that such analysis was possible, and I am certain from Darren Nichols' reactions and questions to me, neither did he." Having considered the trial evidence of DC Winston and Brown, the witness statement of Lee Craddock and the Section 19 interview with DC Winston, the Commission makes the following observations. Both officers have acknowledged that, as the interview process developed, they gained some awareness of inquiries that were being undertaken in relation to telephone data. Both officers have acknowledged that telephone data formed part of the packs which were used when interviewing Mr. Nichols. There is even a suggestion in DC Winston's answer during the Section 19 interview that DC Winston gained knowledge of the cell site analysis and that this knowledge informed some of his questioning of Mr. Nichols. However, the Commission has seen no evidence which suggests that either of the interviewing officers revealed cell site data to Mr. Nichols before he began to give his account on the 14th of May 1996. The Commission notes that the officers specifically denied, both at trial and when asked by the Section 19 inquiry, that they had ever coached Mr Nichols using the cell site data. Mr Craddock has also expressed the view that Nichols was not aware, at the time of his interviews, that police could plot the movements of mobile telephones using cell site data. In the absence of any evidence that Essex Police revealed cell site data to Mr Nichols before he began to give his account on May 14, 1996, the Commission does not consider that this submission is capable of giving rise to a real possibility that the Court of Appeal would overturn the convictions in this case. In any event, the Commission notes that DC's Brown and Winston gave evidence before the Court of Appeal in 2006. The applicants were in possession of the Section 19 materials prior to the appeal hearing and could have questioned the officers at that stage regarding Mr Nichols' knowledge of the cell site data. In all of the circumstances, the Commission does not consider that this submission can form the basis of a referral to the Court of Appeal. Point 5. The applicants seek to rely on the beacon data in respect of Mr Womes and Mr Nichols for the 6th of December 1995, which shows that 2 short calls were made by Womes to Nichols at 18:59 on that date. The applicants submit that this reveals a discrepancy in Nichols' account of events, which has only ever referred to 1 telephone call from Mr Womes at 18:59. The applicants add that, for both calls to register on the cell site beacons, Nichols would have had to answer them by flipping open his phone each time. The Commission has considered this submission, but observes that Mr Nichols was cross-examined at trial by Mr Lederman QC about the number of calls which he remembered receiving from Mr Womes. Mr Womes has acknowledged this in the course of his communications with the Commission. This point therefore does not constitute new evidence or argument for the Commission's purposes. In any event, the Commission also notes that Mr Womes, in his own trial evidence, insisted that he only made 1 call to Darren Nichols at 18:59. In his submissions to the Commission, Mr Womes argues that the reason Mr Nichols referred to 1 18:59 call rather than 2 was because he was coached in his account by his interviewing officers, who were working from a telephone action pack during the interviews. The action pack was drawn up from billing data, and so it would only have referred to 1 call. The shorter of the 2 calls was too brief to have been charged for by Mr Womes' phone company. The Commission has considered this submission, but takes the view that it is pure speculation. The Commission has seen no evidence that the beacon data reveals as a fact that 2 calls were made. It was open to both Mr Womes and Mr Nichols to give their own recollection of how many calls there were, and they both did so in their evidence at trial. Point 6. It is submitted that the schedules of telephone evidence which were prepared for trial by Essex Police were manufactured to underpin Nichols' testimony by omitting, switching and inaccurately attributing data. The Commission has considered all of the applicants' submissions in relation to the telephone schedules, but takes the view that the points raised are not new for the Commission's purposes. When the Court of Appeal considered the applicant's renewed application for leave to appeal against conviction in January 1999, the Court stated the following. In Ground 8, it is argued that the judge wrongfully admitted evidence which was inaccurate in detail and used to corroborate false claims by the prosecution. This relates in the main to schedules of telephone calls which were laid before the jury. It may very well be that there were errors in such schedules. It would indeed be surprising if there were not. It does not, however, appear in particular, so far as the telephone calls on the day of the alleged murders are concerned, that there were errors which in any way put a false gloss on the case. Omission of data. The applicants have pointed out that telephone data reveals that Mr Tate was in contact with Paul Edwards on the evening of the murders, most notably the last call made by Tate's mobile 923 at 18:26 that day, and that Mr Tucker was in touch with Ray Sullivan and Michael Bowman on the evening of the murders. In relation to the submission that these individuals were involved in a plot to murder Tucker, Tate and Rolfe, see paragraphs 194 and 195 below. The applicants highlight that none of these calls feature in the trial schedules of telephone evidence. It is submitted that police withheld details of these calls from the schedules as a way of concealing all references to Edwards, Sullivan and Bowman. The Commission has considered this submission but observes that it was made clear to the jury that the trial schedules only included calls between specified telephone numbers. For example, the schedule labelled Exhibit JMW/2 only featured calls between telephone numbers listed on the laminated sheet for that exhibit, which did not include the telephones of Edwards, Sullivan or Bowman. The trial judge explained the general concept to the jury in the following terms, quote, "The main schedule of course does not include every call. It only includes calls to another number on the schedule of names set out in the plasticized schedule Exhibit 249. You know that there are 31 names there. Outside calls are not included of course, just calls between those 31 numbers." In the light of this clear direction, the Commission does not consider that it can be said that the trial jury was in any way misled about the nature of the trial schedules or the telephone calls which they included. In any event, although the Edwards, Sullivan and Bowman calls were not included in the trial schedules, the fact of those calls was disclosed to the defence since they appeared in the itemised billing and beacon data for the victims' phones. It was open to the defence to prepare their own telephone schedules which emphasised the Edwards, Sullivan and Bowman calls if the defence wished to do so. The Commission does not consider that the submission regarding the Edwards, Sullivan and Bowman calls gives rise to a real possibility that the Court of Appeal would overturn the convictions in this case. The applicants also submit that the trial schedules omitted reference to a call made by Mobile 316 to the landline number 01702 339 636, the family home of Liz Fletcher, a girlfriend of Mr. Tate, at 21:41 on the 6th of December 1995. The applicants state that the fact of this call did not become known to them until a detailed schedule of calls entitled, quote, "All phone calls for December 6, 1995, end quote, dated the 15th of January 1996, was disclosed to them prior to the 2006 appeal to the Court of Appeal. The applicants submit that this 2141 call shows that Mr. Tate was alive and making telephone calls well after 7 p.m. on the 6th of December, and that this severely damages Mr. Nichols' version of events. The Commission has considered this submission but observes once again that the reason the 2141 call does not appear in the trial schedule JMW/2 is because that schedule only contained calls between the specific telephones listed on the laminated sheet for that exhibit, and telephone number 01702 339 636 is not included on that sheet. However, the itemised billing for Mobile 316 was exhibited ESD/1 at trial, so the fact of the 2141 call was disclosed to the defence. The applicant suggests that, notwithstanding the disclosure of the 2141 call via Exhibit ESD/1, the Crown's decision not to include the call in the trial schedule was a deliberate attempt to mislead the jury and to distract attention from a call made by one of the victims well after the time of the murders, as alleged by Nichols. The Commission does not consider this to be correct. There is no evidence that Mr. Tate had Mobile 316 in his possession on the evening of December the 6th. The only telephone discovered on his person on the 7th of December 1995 was the one which became Exhibit PSB/43 at trial, referred to as Mobile 923 above. This being the case, there would have been a greater danger of misleading the jury if the 2141 call had been included in the trial schedule. The Commission considers that the available evidence actually points towards Liz Fletcher having the Mobile 316 in her possession on the 6th of December 1995. Police message M165, dated the 8th of December 1995, details a message from Anne-Marie Whitehead, Mr. Tucker's girlfriend, that, quote, "Tate's old mobile is in the possession of a female called Liz Fletcher." DC Winston's report R8A, dated the 11th of December, describes attending Mr. Tate's home address with Sarah Saunders on the 9th of December, when Miss Fletcher arrived and returned the front door keys to the premises, keys to the Mercedes car, Echo 532 November Mike uniform, and Miss Saunders' mobile phone. The Commission notes that the telephone bill for mobile phone ending 316 was in Sarah Saunders' name. In her police interview on the 13th of June 1996, Sarah Saunders described the same occasion when, in company with Essex Police, she met Liz Fletcher at Mr. Tate's address, and Miss Fletcher returned the mobile telephone which was registered in her, Miss Saunders' name. The calls for mobile 316 on the 6th of December are at least likely to have been made by Liz Fletcher as by Mr. Tate. The Commission notes that telephone number 01702 339 636, which was Miss Fletcher's home number, was called twice by mobile 316 on the 6th of December 1995. This could well indicate Miss Fletcher telephoning her home. In this connection, the Commission also observes that mobile 316 proceeded to call the Fletcher home on the 7th and 8th of December 1995, after Mr. Tate's body had been discovered. The Commission notes Mr. Steele's submission that the calls from mobile 316 on the 6th of December are likely to have been the calls from Mr. Tate to Liz Fletcher, which are described in Miss Fletcher's witness statement S20, dated the 8th of December 1995. However, the Commission does not consider this to be correct. All of the calls from Mr. Tate, which Miss Fletcher describes in her statement, can be accounted for using the billing for Mr. Tate's landline and the billing for his mobile phone 923. In this connection, the Commission observes that Miss Fletcher's work number was 01702 226 347 and not 01702 614 170 as suggested in Mr. Steele's submissions. In the light of the points set out above, the Commission considers that it was entirely reasonable for the 2141 call from mobile 316 not to be included in the trial schedule of telephone calls. The Commission does not consider that the applicant's submissions on this matter give rise to a real possibility that the Court of Appeal would overturn the convictions if the case were referred.